I said, my name is Mike Toth. I'm a constitutional conservative. I'm a Marine, and I'm ready to serve you on the 3rd Court of Appeals. 3rd Court of Appeals is a very important court. It has 6 judges on it. So there's 1, 2, 3, 4, 5, 6 judges. One of the 6, Bob Pemberton, is retiring. So I and 3 other candidates are running for the Republican Party nomination on March 6th. So early voting starts on Tuesday. So I would obviously encourage everyone to get out and vote starting on Tuesday. And one of the 4 of us obviously will earn the Republican Party nomination either in the primary or in the runoff in late May, and then we'll take on the Democrat candidate. And I want to give you the big picture, and then I'll circle back, talk a little bit about myself, my experience, why I'm running. Here's the big picture. There's 6 judges on this court. It is a very important court. It handles appeals for 24 counties. Travis County, Williamson County, Hayes County, all the way to San Angelo, a little bit east of Austin, a little bit north, a little bit south. Real big area. And it handles the most important cases dealing with state law and state regulations. And the Democrats are going to try to take the court. They're going to try to flip the court. How can they do that? There was a little bit of a legislative glitch or a little bit of an anomaly. The Texas legislature added 3 judges to the court a while ago. And they took those 3 judges and they put them up in the same election year as one of the 3 judges that had already been on the court. So what that means in practice is what? 4 people on the court are up for re-election. 4 is a majority of 6. So the Democrats have 4 candidates lined up, one against each of the 3 incumbents, David Purrier, Scott Field, and Cindy Boland. They've got a candidate against each of those 3, and they have a candidate waiting for whichever the 4 of us gets the Republican nomination. So there's going to be 4 Democrats against 4 Republicans, and the Democrats are banking on a Democrat year, and then what? They've got a Democrat court. As you all know, what did the Texas legislature do at the end of the regular session? It passed a sanctuary law. Okay? That law and the fines that the Attorney General can impose under that law, where are they going to be challenged? Where is it going to go? It's going to go to the 3rd court. Everything depends on the 3rd court. You can elect the best legislators for the Texas legislature. You can vote for the best gubernatorial candidate. You can encourage Governor Abbott to appoint the best people. But if what they do goes before judges that want to rewrite the law, what good is it? The battle is in the courts now, and I'm going to talk a little bit about this. And for Texans who are interested in the laws that the Texas legislature passes, and they're interested in what the Texas government is doing, the 3rd court is ground zero. I'll just give you one last data point on this. Obviously, there's the Texas Supreme Court, and we've got a very good Supreme Court. But they only take a very small percentage of the cases. You see, the Texas Supreme Court doesn't have to take any cases. They have discretion over the appeals that they take. Not so with the appeals courts. So the court that I'm running for, 97% of its decisions are final. Because the Texas Supreme Court doesn't have the opportunity to take every single appeal from all the appeals courts across the state. They just don't have the bandwidth. They don't have the resources, they don't have the judges, they don't have the time. The opinions would come out years and years later. So we need rock solid conservative judges on the appeals court, because by and large, their decisions are final, except for the exceptional few cases that the Texas Supreme Court will take. And again, the court I'm going for could go Democrat or Republican this year.
Can the Texas legislature pass a law with a provision that says it's not subject to judicial review, just like the federal government can?
I think so. I mean, there's probably some level, maybe at the Texas Supreme Court, but they can certainly,
The legislature says this law is not subject to judicial review, because the feds can do that with federal review.
Up to the point where they could take federal jurisdiction on the federal side away from every court
except
except
state court review.
Yeah, I'd have to look more into that. I imagine it's similar to the federal system, where you can. The legislature has wide discretion over the amount of judicial review that a particular law, a particular rule can be subject to. But typically, there's at least some level to ensure that obviously rights are protected, and that if there is something that is overreaching, that there is some judicial check to keep the separation of powers system in place. But obviously, whether it's a lot of judicial process or a little bit of judicial process is a legislative question. And as I mentioned before, if you think about the court I'm running for, it used to just have 3 people, now it's got 6 people. So the legislature made a choice, we're gonna let them do more work. So these kinds of things, I mean, you're onto a good point, are constantly legislative questions. As for my background, as I said, I'm a constitutional conservative, I'm a Marine. I have worked to defend President Trump's travel ban with Attorney General Paxton. He's my boss. We've worked to secure the border. We've worked to ensure for extreme vetting for refugees coming into this country. And we have fought federal overreach all throughout the Obama administration. You know, people used to ask me, what do you do for a living? I said, it's real simple. I work for the Texas Attorney General. I wake up, I go to work, I sue the Obama administration. And when I get tired with that, we sue the city of Austin, which we also did quite a bit of. So that was kind of the 1-2 punch when Obama was in office. A lot of suits against the Obama administration. I want to talk just a little bit about what all those suits mean and kind of what it says about our country, and then some suits against the city of Austin. When we were suing the Obama administration, you know, we were suing over federal rules and regulations by and large. And you know, I think for a lot of people, this was sort of a kind of a new reality if you think about it. I mean, the issues that I think our country faced for a long period of time were Congress. You know, the laws that Congress are passing. Are Congress passing good laws? Are they passing constitutional laws? You know, those were the questions that Americans thought about when they thought about the courts. You know, I like the hat over here, make Congress work again. Well, what happened as the Obama administration went on was it seemed like the majority of the action, the majority of the things that people were reading about that we were working on from the federal government wasn't from Congress, it was from administrative agencies, from lawyers, from bureaucrats, from unelected officials in Washington. And I just want to kind of give you a quick way to sort of think about this. If you think about our lawsuits against the federal government, and we sued the federal government basically once a month. I mean, as Attorney General Paxton has been in office once a month, but if you go back before then to Attorney General Abbott, now Governor Abbott, it's about once a month during the entire 8 years of the Obama administration. That's a lot of months, that's a lot of lawsuits, right? So here's the interesting thing, is the first lawsuit against Obamacare was a lawsuit about a federal law. Congress passed a law called the, quote, Affordable Care Act. And the question in that lawsuit is this law passed by Congress consistent with or in conflict with the United States Constitution? That is a constitutional law case. So the question was, does Congress have the commerce power authority to do this? Well, Congress has the power to regulate commerce, not create commerce. And they were telling people to go out and buy something, so it seems like it's not within that congressional power. The Supreme Court actually agreed with that, but then they found a taxing power authority that was never argued. The president had said 22 or 24 times it wasn't a tax. Anyway, we don't need to rehash old history. So the US Supreme Court ultimately says, this is constitutional, it's within Congress's taxing power. Okay, that was one lawsuit about one law that Congress passed. Every single other lawsuit that we brought against the Obama administration wasn't about Congress, it was about the Obama administration. So if you think about all these lawsuits, they weren't really constitutional cases, they were administrative cases or regulatory cases. They're not about a law that Congress passed, they're about an action that the Obama administration, that one of the agencies of the Obama administration, the EPA, the Department of Labor, the Department of Health and Human Services, they're about all of that, okay? So what does this say about the Obama administration? What does this say about the important work that we in the Texas Attorney General's office did? The Obama administration was trying to move the United States into a post-constitutional America. Okay, that is the issue at bottom, is by and large, throughout the history of the United States, major policy changes, good or bad, came from the Congress. They came from your and my elected representatives in Washington that could be voted out of office, that could be removed from office. The Obama administration was saying, we're done with the Congress. We're done with the lawmaking authority belonging to the Congress. We're going to take that authority and we're going to make policy changes, rights changes, legal changes through the executive, right? So a couple easy examples of this. Executive amnesty, right? Changing immigration law without a single congressional vote, right? Without an ounce of congressional authorization. Okay, the president is saying, your legal status used to be this, now your legal status is that. The president of the United States changing legal rights. Okay, this is a legislative decision that's being taken by the president, and the president is doing this. The president of the United States said dozens and dozens and dozens of times, I'm not a king, I can't do this. What happened was the administration ultimately realized that the way that the Constitution had delegated authority was no longer convenient. And we needed to move into a new era where the Constitution and the limits that the Constitution places on the different branches of government no longer applies. You may recall, if you go back in history into the 70s and 1980s, what folks on the other side of the political or judicial spectrum used to say is, we want a living Constitution. Okay, a living, I like Justice Scalia, he said, I prefer a dead Constitution. Okay, a living Constitution was, you know what, the Constitution still applies, but we're going to kind of let it breathe a little bit, open up the bottle of wine, let the air come in, let it breathe a little bit, expand the terms. Okay, so commerce in the Congress's commerce power has a broader meaning than it used to have. That is different from what the Obama administration which is doing, which was, we're just going to move beyond the Constitution. So forget about a living Constitution where we still follow it, but we just give a broader understanding to some of the terms and a little bit more flex in the joints. Forget about that. We're just going to move past the Constitution to where the executive can change immigration law, the executive can change labor law, the executive can change the First Amendment, right? Last time I checked, the First Amendment protects religious liberty. Last time I checked, religious liberty is an equal civil right on the same plane as all other civil rights, right? And the administration was taking decades of congressional law, decades of precedent, decades of understanding of what the Constitution, and just putting it all off to the side. Not letting it breathe, even, which I don't think is a good idea to begin with, but just pushing it off to the side. That's where the Texas Attorney General's office came in, filled the breach, worked with a lot of other cases, a lot of other states, and by and large were successful in at least holding things off. Now, since then, and I just want to sort of pivot a little bit to kind of what's going on right now, why I'm running for this particular court, what's the situation now. So I'll just give a very brief summary of sort of where we are right now, what the stakes are. So if you think again about the Obama administration, post-constitutional America, that's the vision. Had Hillary been elected, and instead of Neil Gorsuch, we get Merrick Garland, whoever it is, you would have had 5 votes for executive amnesty, no question about it. And what 5 votes for executive amnesty is 5 votes for the lawmaking power being transferred from the Congress to the president. And that's not just going to be a precedent for immigration type cases, that's going to be a precedent for any other kind of case where the power used to belong to the Congress and now belongs to the executive, right? So that is what, among other things, was at stake in 2016. Obviously, President Trump won. Not only do we have Neil Gorsuch, but the other judicial appointees across the board from the district level to the appeals level to the Supreme Court have been absolutely fantastic. So that's the situation by and large that we've gotten into since 2016. However, what is going on right now is just as the Obama administration, these same forces were trying to rewrite the Constitution through the executive under Obama, they're now trying to do it through the courts. Not every single court, but they're selecting particular courts and they're going to those jurisdictions and they're seeking those judges to do exactly what the Obama administration did for the previous 8 years and rewrite the law. And I'll just give you one example of this, the travel ban. 44 travel bans since 1980. Okay, 44. And we had President Carter in 1980. Obviously, Reagan took over in 81. So there's Carter travel bans. There are Clinton travel bans, and there's Obama travel bans, and there's H.W. Bush travel bans, and there's Reagan. There are 44 travel bans since 1980. Pretty much every president has done it. And why is that? Because Congress gives express authority to the President of the United States as Commander-in-Chief to protect the homeland. And there's a congressional statute that allows the President of the United States explicitly and expressly to designate individual countries wherein their foreign aliens can't come into the United States for national security concerns. It is a clear congressional grant of power, which is only a restatement of the President's constitutional authority to protect the homeland. And the United States Supreme Court, since the 1950s, has upheld this use of executive power given by Congress, protected by the Constitution, and upheld by the United States Supreme Court since 1950. That's why you get 44 travel bans without a blink of an eye from anyone. So what do you have now is you've got federal judges who, again, like the Obama administration, are just saying, we don't like this. We don't like the laws that Congress has passed. We don't like the decisions that the American people have made through the Constitution and how they've delegated authority. We don't like the precedents that have existed for decades in the United States Supreme Court. And we don't like President Trump. And therefore, we're going to stop this. You have judges who are following the president's Twitter feed rather than following the law. And it is essentially the same move that we saw in the Obama administration, just shifted into the courts now, which is a complete power grab and a complete undermining of all the laws and the constitutional protection and everything put into place.
What should be the consequence of a judge not following the law?
Yes.
Right, well, I mean, overturned by the United States Supreme Court to begin with.
What about impeachment?
Right. I mean, that's ultimately going to depend on the Congress. Now, I will tell you, the U.S. Supreme Court, by a 7-2 vote, I mean, this is before the 4th Circuit just ruled on a travel ban case, but if we think about the 9th Circuit, the U.S. Supreme Court came in a 7-2 vote and put a stay on the 9th Circuit's opinion. And that was, I mean, there's been a lot of news and there's been a lot of things going on, and it didn't get a lot of coverage. But it was a sign that the U.S. Supreme Court understands that there are runaway circuit courts out there on important questions of federal law, including immigration and defense of the homeland. We need, I think, just to answer your question real quick, you know, the U.S. Supreme Court, I mean, obviously, we need more time for more Trump appointees.
You're familiar with the doctrine of the lesser magistrate?
Somewhat, but yeah, tell me more about it.
Well, it's basically the smaller magistrates at a lower level can say no, even to the federal court.
Right.
But in Trump's position, he's the President of the United States. The authority is delegated to him, not the lower courts. So you got multiple problems here.
Yes, you
One
do.
of which Congress won't do their job because
Right.
under Article 3 of the Constitution, Congress writes the rules.
Right.
All they have to do is real quickly pass some legislation that shuts those rogue judges down.
Right.
And the president, by the nature of his office, can say, you have no authority to make that decision, and ignore it, and then force them to take it to the Supreme Court.
Right. Yeah. Our sense on sort of the congressional priorities now, with the margins being so slim in Congress, is that they're trying to put essentially all their efforts in 2018 into just confirming more judges. And they did. I mean, the numbers were good in 2017. They did pick up the pace as the year went on, and then got a number of different judicial confirmations in. But that still leaves a couple circuit courts where I think the battles are. Now, for me, you know, Texas is not exempt from this process, where you're going to have the special interest groups on the left seeking to go to particular judges and particular courts to undo constitutional provisions and undo statutory provisions. Texas is not exempt. As I said on the front end, we're looking at a court which is going to handle and has been handling very important state cases, including laws like the sanctuary law that the legislature put into place, possibly falling into the hands of the Democrats in 2018. They have a theoretical possibility. 4 justices up, they've got 4 candidates, there's only 6 people on the court. So as I've been looking at the situation across the country, working with Attorney General Paxton, I've seen that there is a real concerted effort to go to particular courts, and the court that handles appeals from Travis County, appeals from Williamson County, the court that really affects you and your lives, hangs in the balance here. And so we need candidates who have experience with constitutional law, experience with administrative law, who understand the big picture and have conservative principles and backbone stepping into these races. So that's why I got into the race. Yes?
One additional thing, and your opinion on this, is Article 6 of the Constitution defines the law of the land. And the law of the land is the Constitution and all laws passed in pursuance thereof.
Right.
So all of these rulings that are coming on based on case law, there's nothing constitutionally recognizes case law. It recognizes the constitutional law.
Right. Right.
So
Treaties.
what's your position for taking a strong stance on saying that these case law are actually unenforceable?
Well, the thing with case law, I mean, if you take something like the Heller decision, right? So the Heller decision is a U.S. Supreme Court decision from 2007, where the United States Supreme Court says the Second Amendment protects the individual right to bear arms, right? So this is a great opinion written by Justice Scalia. So, I think, obviously in my case, I read the Heller decision and I say, okay, perfect. Yeah, the Heller decision is a good decision. But it's a good decision because it reflects the original language of the Second Amendment. So I think the most important issue here is are judges doing their jobs and accurately reflecting the language that the framers have put into place or the Congress has put into place if we're dealing with a statutory question. There are examples of cases, again, I use Heller as a great example, where you've got a very, very good, strong opinion. The opinion is good and it's strong because it's accurately reflecting the constitutional text. I'll just leave you with just one last thing.
Give one quick input on the Prince versus U.S. 1997.
Sure.
What's your opinion on that?
The anti-commandeering case? Yeah.
Well, that was the one,
Federalist.
The Fed's trying to enforce the Brady Law out in Arizona.
Yeah. Well, we've, in the Texas Attorney General's office, we've used Prince and some other decisions from the 1990s, obviously, to protect the autonomy of the states. We use decisions like this in a number of cases in the latter part of 2016, where you really had kind of the Obama administration coming in and trying to co-opt sort of state bureaucracies to get them to essentially input federal mandates that, again, getting back to the big question, were nowhere based on actual congressional law. So this happened quite a bit in 2016 around questions of religious liberty and conscience. Federal law, and it's all over the place, protects religious liberty, protects the freedom of conscience. So a couple examples. If you're a physician and you're against the death penalty, you do not have to inject an individual who's going to receive capital punishment with a lethal drug. You don't have to do that. Doesn't mean the person's going to survive. Doesn't mean that the capital punishment is not going to be imposed. It just means you as a physician don't need to do that. Similarly, if you're a physician and you have a religious or conscious objection to abortion, you do not have to perform that particular procedure. What we saw in the end of the Obama administration was a real shift away from, again, these long-standing, numerous congressional protections for individuals at every level of American society. This affects Prince and other decisions of the U.S. Supreme Court in the 1990s because some of these officials, some of these individuals who the Obama administration was seeking to take away these rights work for the state of Texas, right? We've got hospitals. Most of the people are just private individuals working for a hospital or working for a private business, but some of them are state employees. So we came in, obviously we were protecting the First Amendment, which provides for religious liberty. But on top of that, we were also protecting our authority over our officials. under Prince and other decisions from the 1990s. We were able to get, and this is mentioned on my push card, a number of nationwide victories. The Trump administration then took down these rules and guidance documents, so basically we have a victory for now on these issues. And they've also established some organizations, some agencies within the federal government to further protect conscious rights and religious liberty. Just the last thing on me, and then I'll take any other questions. Empower Texans, Texas Right to Life, Texas Homeschool Coalition, Texas Values, and obviously the Attorney General of Texas, Kathy Adams, Joanne Fleming, they've united behind my campaign. I hope you will too. We are in the home stretch and we're finishing strong. Early voting starts on Tuesday. I'm going to go out and get you some push cards. I'm happy to answer any more questions or assist you in any way that I can, either through myself or my team members, to get folks out to the polls, get your friends out to vote. Yes, sir.
I have one question that this group might be very interested in on the Third Circuit.
Sure, on the third court.
Third Court.
Yeah.
Last year, they heard a case brought by Laura Preston.
Oh yeah, good. I'm glad you asked. Yeah.
And as far as I'm concerned, they punted.
Right.
They did not address the two main issues of
Yeah.
Secretary of State granting waivers when he had no
Right.
authority,
Yeah.
and no picture of the ballot.
Right.
They just punted
Yeah.
completely, would
Yeah.
not address those,
Right.
addressed some minor things, and upheld the fines against her and her lawyers.
Right.
So what's your thoughts
Yeah,
on that?
no, it's real simple. Yeah, I'm a co-author on the amicus brief that the Texas Attorney General's office filed on behalf of Laura at the Texas Supreme Court. So yeah, we're on Laura's side on this one, and we were happy. I mean, Laura, I guess a number of you know Laura. She's absolutely brilliant, and I always tell Dr. Presley, she brings the best ideas and the best opportunities to the Texas Attorney General's office. So. She came to us during the course of that litigation, and we were happy to come in at the Texas Supreme Court with an amicus brief. I mean, obviously, we feel that there are substantial issues around the way voting has occurred in Texas. In addition to what we've done with Laura, we've prosecuted folks at the Texas Attorney General's office for voter fraud. So, the Texas Attorney General's office, it has 800 lawyers. It would be the largest law firm in the state if it were a private law firm. The vast bulk of our lawyers do civil work, with a few exceptions to that where the legislature has given us criminal jurisdiction. Election law is one of those areas. Election law obviously goes to just the heart of the American and the Texas democratic experiment. If you can't trust the individuals that the people have elected, if you can't trust that process, all the other stuff that I've said about we need to rely on the rule of law, we need to rely on what the representatives have put in place, not the bureaucrats, it all falls away if we can't trust the process for picking those representatives. So we have prosecuted, we put people behind bars. I would encourage everyone, apart from please voting for me, to continue to encourage your representatives to give us the resources that we need to hire more investigators and more prosecutors on the election fraud. I mean, ultimately our budgets depend on the legislature. We have some folks that work in that office, but as I said, we've got 800 lawyers, and frankly, the vast bulk are not doing that kind of work.
When you have time at a later date, I can give you much more background on
Please.
voting fraud. But one of those judges from the Third Court, after the decision, I cornered him at a Republican barbecue, and he gave me those most weenie answer I've ever heard about why Laura's case had weaknesses. It was unbelievable.
Bill, who was the guy that also in Laura's told us that we didn't have to have paper about?
Oh, that's a big problem.
Yeah, that's an issue. I
Well,
think that.
Keith Ingram is the
Yeah.
focus of the problem,
Yeah, I
but there
couldn't
was
remember his name.
one more quick, I'll try and make it short as possible, but after Laura had a press conference over a year ago, she distributed paperwork to all of the legislators, including the lieutenant governor, governor's office, etc. Anyway, for whatever reason, I was one of the people who got a response from Abbott, and we talked about, well, this is the purview of the Secretary of State. And I sent him a letter back, and I said, well, the Secretary of State is the problem. And 3 weeks later, he resigned, and they just put another, what I call, not so conservative in his place. But the focus of her question is Keith Ingram, who was granting waivers,
Right.
comes from the background of the law firm, the Rose Law Firm. And he actually, his first job as a lawyer was the father of the guy that I graduated with in high school that's a liberal lawyer in Houston right now. And I can give you a bunch more detail on that.
Sure.
But he comes from that international connection of lawyers who want a flexible constitution and want to ignore the provisions.
That living constitution again.
So anyway, bottom line, that guy needs to be fired.
Let's catch up offline. Yeah.
Okay.
Yeah, since you obviously support the federal government being limited to those powers that are articulated to them.
Yeah, enumerated, sure.
Enumerated, okay. Would you support legislation to outlaw the publicly funded resettlement of refugees in Texas?
You know, so we have, so here's the issue with judges, right?
I need from the Attorney General.
Yeah. So, well, I guess the important thing to sort of understand with regard to judges and judicial candidates is, let's say there is that legislation, right, and comes before the court and I'm on the court, right? So the first thing that would happen if I answer the question is obviously I would get kicked off the case and I wouldn't be able to rule on the case. So, you know, I worked for really one of the great conservative champions in the federal judiciary. Edith H. Jones is her name, and she's a Fifth Circuit judge, so she covers the Fifth Circuit Court of Appeals, which is a federal court that covers Texas, Louisiana, and Mississippi. And you know, folks were always trying to get her recused. And you know, she would always say, "Hey, look, you know, I really have to stay disciplined in sort of commenting on some of these public policy questions because do you or don't you want to lose Edith Jones's vote?" You know, so it's sort of that type of issue, I think, with the state judges as well. I mean, at the end of the day, you know, we run to serve you, we run to serve the people of Texas, and the way that we serve the people of Texas is what? We hear cases, we vote on the outcome, and we write opinions. And if judges get too far out there in terms of commenting on that's a good idea or that's a bad idea vis-a-vis legislation, then if that legislation ever comes up, that particular judge really can't handle it. So in any case, so such is role of the judges. But you know, of course, as a judge, you know, you've got to follow the law. And when the Texas legislature or the U.S. Congress acts according to a power that they have, you know, the judge's job is not to second guess or psychoanalyze what the Congress or the legislature has done, but to take the words that they put into place and apply them.
Of course, the key phrase is in courts.
Right, pursuant to the Constitution. Yeah, absolutely. Right, that's the supreme law. Yeah. Yes, sir.
Are you any relation to Steve?
No, no. I finally met him. I met him during the campaign, and
He's a good one.
he's a great guy. Yeah, no, I think so too. Yeah, very nice guy. And the Attorney General served with him in the Texas House, and it looks like he'll be back in the Texas House. But yeah, the Attorney General asks me that all the time too. So I'm glad I finally had a chance to meet him. We took a picture together early on in the campaign. No relation though.
He goes to the convention every year or every 2 years when he's active.
Yeah, he is.
People.
Yeah, great reputation. Yes, sir.
Excuse me, you said that basically the AG's office was suing about once a month throughout the Obama administration.
That's right. Yeah.
Just out of 100. I know it takes a while for these things to work their way through, but what was your batting average of the ones that did make it through?
Yeah. You know, it's funny. Yeah, we just were talking about that in the office. So under Attorney General Paxton, I think we just tallied that we had something like a 70% win rate. Now, you know, it all depends how you count it. I mean, if you think about 2016, there was the Obama sort of quote unquote bathroom guidance. We got a nationwide injunction against that. There was an HHS rule we also got a nationwide injunction against in 2016. There was something called the overtime rule, which would have increased the cost of doing business for tons of different industries without any kind of congressional input. We got an injunction against that, and then also something called the persuader rule, which is kind of a soft to unions. We got an injunction against that. So if you just think about 2016, I mean, we went out with a bang. Now, some of this might have been that the Obama administration by 2016, I mean, the wheels were off the bus at this point. And but then what happened is the Trump administration took over and basically did away with the underlying issues in each of those cases. So we won at the trial court. Who knows what would have happened at the appeals court? But you know, a win's a win.
if I can just read something you said.
Yeah.
You said the judges have to follow the law.
Yeah.
I love the Ninth Circuit did that for the change.
Right, yeah, that would be nice. That's right. Yeah, if you ever work at the U.S. Supreme Court, you get a case from the Ninth Circuit, just write reversed.
Yeah, 80%.
Stamp.
That's it. Great. I don't want to take any more time. Last thing is we are looking for folks to help out with some phone banks we're putting together. So I'll pass a sheet around with the push cards. And we got a great team of volunteers, probably a lot of folks that you already know across paths with. So
There's 6 precinct chairs in here, so bring them up to push.
Oh, good. Okay, yeah. I'll get you all a bunch of material. Great. Okay. Well, thank you all for your time.